currently drafted has been structured, and try and get feedback really as to what we need to be looking out for and making sure we get right when it comes to the final draft. For those of you who have seen the consultation, we do of course have a draft set of regulations included in that. It's very important to stress that just because we've gone as far as drafting regulations doesn't mean that we regard it as done and dusted. This is very much a living document, and we are certain that it will change as a result of the consultation process. It's just we find that with previous consultations it's been easier to explain what it is the law is trying to do if we've actually got a draft of the law, and it also allows lawyers on the island more time to pick it apart and make sure that we've got every single piece of it right before we go into the next stage. So hopefully that will mean that we'll be able to promptly get this into law by, I'm looking to Kate here, is it September next year? We'd expect this to come into force. One of the things that's difficult, or perhaps more challenging about a disability discrimination law is when it comes to definitions in terms of who the law protects, and trying to come up with a way of defining disability in a way that takes into account the incredible variety of ways in which people might experience disability, but without going so wide and becoming so vague that people don't understand when they've got a legal obligation and when they haven't. So the first major challenge in the regulations is to come up with a definition. Now and I'm going to flick through slides and I'll make sure I read out whatever slides I'm relying on. There is a definition in the UK of disability, which I think it's fair to say is quite medical. And it's a quite technical definition, and there is 20 years of case law trying to figure out what this definition actually means in practice. But in broad terms, we say that a person has a disability if they have a physical or mental impairment which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. And you can take almost any phrase in that, and I can show you several pages of case law trying to figure out exactly what those provisions mean. So long-term, for example, means 12 months. So the effect has either lasted for 12 months or is expected to last for 12 months. Substantial means not trivial. It was really handy to get that clarified in the law, but that's what the law says. And day-to-day activities is where I think there's perhaps been more difficulty in the UK than any other area, where tribunals have to go through a rather odd process of analysing the life of the person in question and figuring out what day-to-day activities they are impaired for them. And that was something that we didn't really want to get into with the Jersey version. And also, to an extent, it's been superseded by work that's been done in the United Nations. The United Nations has a convention on the rights of persons with disabilities. It's been pointed out to us that this convention doesn't have a definition of disability, which is technically true, but it has got some good clues as to what it means by disability. It does say that disability is an evolving concept, which I think captures quite nicely the difficulty you have in trying to capture it in the law. But it says that persons with disabilities include those who have a long-term physical, mental, intellectual or sensory impairment, which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. So in the United Nations concept of disability, we have much more of a social model of what disability is rather than a medical model. So rather than looking intrinsically at an impairment and seeing what effect it has, you acknowledge that there's an impairment, but you acknowledge that the disability arises not through that impairment per se, but through the way that interacts with the way society operates and the barriers that are placed in somebody's way. And I think that's a really crucial thing to take forward in terms of what disability is and what the law should be covering. The question is there a way that we can capture that in the regulations that still keeps us with a definition that the lawyers within government are happy is a sensible definition and something that has a certain amount of robustness to it. So the proposed definition that we're consulting on sort of takes some of the provisions from the UK Equality Act, but leavens it very much with the way the United Nations has approached the concept of disability. And we say that the person has a protected characteristic of disability if the person has one or more long-term physical, mental, intellectual, or sensory impairments, which, when taken together, if more than one, can adversely affect the person's ability to engage or participate in any activity in respect of which an act of discrimination is prohibited under this law. Now, if that sounds like a mouthful to you, you should have seen some of the earlier versions we were trying to deal with. But if I can break down what I think is useful about this definition. First of all, we lose the concept of normal day-to-day activities. So we're no longer trying to assess the life of the person who's got the disability. We're instead looking at that aspect that interacts with the discrimination that they're potentially suffering. So if it's an employment case, you look at the way in which it affects the way in which they operate in the employment sphere. If it's a housing case, if it's access to a restaurant case, you look at how the disability would interact with the barriers that may be placed in the way by the structure of a building, or the way in which a building is rented, or the way in which a restaurant is operated. We also don't specifically define what long-term means, because we found that in the UK, that can be a significant barrier in trying to figure out whether someone's got a disability or not. And we hope, and this will be interesting to see whether people agree on the consultation, that it can be left to the tribunal to decide from a common sense point of view to distinguish between a temporary injury or a temporary illness, like someone's got the flu, which I think we don't want to be a disability, and something that is more sustained, where it would be appropriate in context for them to be protected by the legislation. We also say can adversely affect the person's ability to engage or participate. So what the tribunal will be asked to look at is the potential for this condition to have that effect. It is a much wider concept of disability than the UK has. So this will, we hope, provide, first of all, more certain protection for people who in the UK might be on the cusp of whether they would count as being disabled or not. And it will encourage employers and those providing services not to get bogged down in trying to figure out whether someone qualifies for protection. Because I know as a lawyer in the UK, this is something that is a constant thing that we have to battle through, where the employer says, yeah, but is he actually disabled? Would he meet the definition? With the idea that they're not going to start making adjustments until they're persuaded that they've tipped over this level of seriousness. I think it would be better if it was a more open concept, but we'll see how that plays in terms of the... And I was going to say, are there any questions on that? And I'm delighted to see that there are.
Mike Curl, Dean of Jersey, could you just unpack those 4 words, if more than one, because I'm struggling to understand that.
Yes, so it may be that you have a number of conditions which, if you took each of them individually, each would individually not have a sufficient impact to amount to a disability. But if you look at the combined effect of the conditions, the person is disabled. So if more than one is simply saying, well, if you've got more than one condition, what we're looking at is overall what is the impact on you. Now that's what I've said without looking and checking that that's indeed what it says. So let's just make sure if it has one or more long-term yes, which when taken together for more than one can adversely affect. So that's what it does.
So does that mean that if a person has only one severe disability, that they're not protected?
No, because if you break down the sentence, if the person has one or more, so let's just say they have one long-term physical, mental, intellectual, or sensory impairment, which can adversely affect.
Okay.
I agree, I find that very confusing, which taken together, I have one disability, in fact, when I was down this side. Well, reading that, it could be interpreted as I haven't got more than one, so I'm not disabled.
Well, it's worth making the point that there might be a way of making that more clear. I'm happy as a lawyer that is what it says, right? So I'm confident that the tribunal could not interpret it that way, but obviously if people might interpret it that way, then that's a concern that we need to look at. Certainly the intent would be that you could either have one condition which has this effect, or you can have several conditions which individually don't have this effect, but when combined do. So that's the intention behind it. I do think that is what it says, but if there's a way of making that clearer, we can have conversations with our law draftsmen and make sure. I will come back to you, but there was a point behind you. It was the same point, which does suggest that it's something that we do need to look at. If more than one person comes in at the same point, obviously that's something we need to look at.
I actually think it is problematic. Worst case scenario, it looks like that if you only have one condition, that you are not protected. I know it doesn't say that, but I'm always thinking worst case scenario. I think I need to redraft, but I'm just a priest.
We'll make that point.
Thank you.
So,
yeah, the fact that you've got different definitions under different laws, the worked example, does that arise to conflict anywhere? Can people say, oh, that doesn't apply under the United Nations, for example? That's a lesser standard, and this is a higher standard. Well, can people use that to mitigate, say, well, they won't go for the higher standard, they'll go for the lesser standard?
No, people will be looking at this definition. This is the definition that would apply in Jersey. It's conceivable that if there was a fine judgment for the tribunal to make, then somebody might use things that have been said at the United Nations level, knowing that Jersey would want to comply with the United Nations principles. It might well be that would be something they'd take into account, but that would only be if they were otherwise stuck. I don't think there's any question that this is the definition that would apply. Any other questions or thoughts about our definition? So if we,
when taken together, you already said if a person has one or more, and then it's almost like that sort of phrase inside the comments is throwing you out of sentence.
It breaks up the sentence in a way that's obviously a problem. So what I think we will do, and I'm saying what I think we will do while looking at Kate, what I suggest we do is we talk to the law draftsman's department and we see if we can persuade them that taking those words out doesn't change the meaning. And if they're worried about it changing the meaning, then we'll see if we can create a separate little thing that will get inserted later on, so it doesn't interrupt that overall paragraph. So that paragraph is clearer, but if the law draftsman needs a technical provision taken together, if more than one, and we have to be honest to take advice from the law draftsman's department when we're drafting these things, we don't just get to say exactly what we want. If that can be put in later, that might be easier. Does that sound horrific, Kate? Does that sound like...
We can definitely do that.
We can do that.
Definitely ask those words tonight that come out and will be phrased slightly.
Cool.
You can't tell them what to write.
Yes, exactly. You can't. It's a delicate process coming up with drafting law. It would be terrific if we could just sit here and draft one. But all the laws drafted in Jersey have to go through the law draftsman's department to make sure that there's a consistency in the way in which laws are drafted, because otherwise people say, well, you used this phrase in one law and you didn't use it in another, and that creates confusion. So there's always an element of negotiation to get these things through. We'll see how we go, but the point is certainly taken and noted.
As long as the lawyers are happy that it says what it can say, the guidance can say something completely different.
Yeah.
That people agree.
I mean, that is one of the debates you have with drafting laws, to how much you rely on the law saying technically one thing and then the guidance making it clearer, or whether you expect people to be able to just look straight at the regulation and immediately understand what it means. The most important thing is that, and this is going to sound odd when I say it, but I think it is true, the most important thing is that lawyers reading it have the same understanding of it. because the last thing you want is different lawyers thinking it means something different, because that creates all sorts of chaos. If we can also make it so that it's plainly understandable by everybody, then that's fantastic, and we'll do our best to do that. Anything else about the definition strike anybody? So, we'll see how that goes, and obviously this is the first meeting where we've discussed this, so we'll talk about that more with other people as well. What I also wanted to do was just highlight some of the consultation questions that we're particularly keen to hear from people on. A lot of that's around the definition, and take your points on that. There are two forms of discrimination that we are creating, essentially, to deal with disability, which I think it's worth highlighting. The first is what we might call disability-related discrimination, which will be slightly wider. Generally speaking, if you treat someone less favourably than somebody else because of a protected characteristic, we call that direct discrimination. But that can be quite a narrow right. So for instance, suppose I say, you can't bring your guide dog into my restaurant. Is that direct discrimination? Am I discriminating against someone when I do that? Instinctively, we'd think yes. But on the law of direct discrimination as we currently have it, the argument would be, I don't object to you being blind, I object to the guide dog. It's the dog I object to, not you. So I'm not treating you less favourably because of your disability. And that would, I think, obviously be unsatisfactory. So we have a provision which we can call broadly disability-related discrimination, which means if you treat somebody unfavourably because of something that arises in consequence of the disability, that too would be discrimination. So if I refuse to let you in my restaurant because you have a guide dog, because that is something that arises because of your disability, that would be regarded as direct discrimination too. Now that's quite a wide form of discrimination. So what we also have, and this mirrors the UK, is a defensive justification if what you're doing is a proportionate means of achieving a legitimate aim, which is a phrase that crops up several times in the course of the discrimination law.
Can you say that again?
Yes, I was going to give an example, if I may, of how that may work. So suppose what you've got is, as an employer, you've got someone who has been off sick with a very serious condition for a year. And as an employer, you think, well, I think we've now gone as far as we can. I can no longer afford to employ this person. If I were to dismiss that person, I would be treating them unfavourably. I'm treating them unfavourably because of their absence. And their absence arises in consequence of their disability. So, on the face of it, that would be discrimination, because I'm treating somebody unfavourably because of something that arises in consequence of their disability. So what we say is, well, there may be a point at which that's a reasonable thing for the employer to do, and we shouldn't make that illegal in all circumstances. So there's a defence if the employer can say, but I've done my best to try and get this person back to work. I've done what I can in the workplace to make it suitable for them. I need to have the job done, and this person isn't going to be capable of doing the job. So it allows them to defend themselves if what they've done is overwhelmingly a reasonable thing to do. And that reflects the way the UK currently works. Does that make sense?
What's the phrase again?
Which phrase? Proportionate means of achieving a legitimate aim.
Yes.
Yeah, sorry, that does rather trip off my tongue, because I've been saying that over and over again for about 15 years now, and I forget it'll sound alien to most people. So what we say is, we first of all say is, what's your business objective? Your business objective might be to make a profit, it might be to provide a particular service. So that is your legitimate aim. Our next question is what you've done, dismiss this person, a proportionate means of achieving that legitimate aim? And that requires us to balance the impact that what you're doing has on somebody with the need that you have to do it. So the more important your aim is, the more your aim is in question, the easier it is for you to justify what you're doing. Does that make sense? So it's a balancing act where the tribunal is looking at, has the employer basically got to the point where this is a solid, reasonable thing for the employer to do, or should they have done more? And that's the sort of question that we ask the tribunal to sort out.